Well, Vashon, today is Tuesday.
Today is Tuesday, one thing closer to Friday.
Yes, we are. And it's a beautiful day outside. All right, everyone, have a seat. I'm going to call the docket. When I call the docket, I need you to stand when your name is called so that we will know that you are here. If you do not respond, we're going to assume you're not here or that you're late, and a warrant may be issued for your arrest. Robert Shannon Klein. Thank you. Jessica Decimito. Jessica L. Decimito. In custody, Joseph Balboa, Abby Marino, Michael Rodriguez. Michael Rodriguez. Maybe he didn't make it out of jail. We shall see. Jesus Garza. Jesus Garza. Oh, I think he is in federal custody. Jose Lozano. Thank you. Alexander Castro. Thank you. In custody, we have Christopher Rodriguez. Luis Guillaume Hernandez. Did I pronounce that correctly? Yes. Sarah Wilson. Antonio Rios. Antonio Rios. George Santibanez. Vashon, maybe they're out voting because it is the last day to vote.
Yeah, that.
Brian Maldonado. George Santibanez. Thank you. Kevin Savagia. Thank you. Joe Blakely, custody. John Lyles, custody. Roberto Rosales. Roberto Rosales. In custody, we have Gus Gallegos. Paul Bell. Paul Bell. Larry Holmes in custody. That's the boxer. Okay, I'm sorry, you didn't get the reference.
I did.
Does not know who Larry Holmes is. Now I'm disappointed. Raymond Uribe, custody. Jerry Mendoza. Deputy Mejia, you know Larry Holmes, right?
I don't.
Oh my gosh. Could I get a new deputy in court, please? Jason, you know Larry Holmes. Well, that's like saying you don't know Sugar Ray Leonard. Yes. Jose Gonzalez.
Present, Your Honor.
Thank you. Zachary Gilmore. Jay Juarez. Do I pronounce that Jay? Am I
Juarez.
Juarez? Jay Juarez. Jose Carmona. Thank you. Renee Angel Cantu. Good morning. Cesar Gutierrez. Cesar Gutierrez. Victor Garcia. Custody, Diego Mascaro. Roberto Rosales. Roberto Rosales. Benicia Davis. Thank you. Robert Solis. Jose Amescus. All right, thank you. Luis Herrera. Edwin Rosario Montes. Good morning. Jordan Estrada. Jordan Estrada. Christopher Black. Christopher Black. Oh, he's on Zoom. Albert Bishop, custody. Darian De La Rosa, custody. Christopher Gonzalez. Christopher Gonzalez. Brandon Sierra. Thank you. Dylan Parker. Dylan Parker. Trayvon Stevenson, custody. Marcelino Padilla, custody. Delton Bailey, 130. All right. Is there anyone who came in later? Your name was not called. Yeah. What's your name?
Paul Bell.
All right, let me see what page you're on. All right, we will get with you. Is there anyone else who came in late or your name was not called? All right, everyone, these are the rules of the court. And I'm gonna put emphasis on certain things based upon what happened yesterday. Attorneys, if you are ready to approach the court, you need to have done certain things. Confer with the state, confer with your client. If your client is in custody, yes, they need to be brought out. If your client wishes to speak to the court in a language other than English, we need an interpreter. After you've done all those things, approach the clerk or the coordinator, ask them to place your file up here, and I will call you in the order of appearance. If you do not approach and have your file placed, I'm not a mind reader. I'm not going to know you're ready, and you're going to sit here. We are recessing at 12. Please do not rush the court at 11:45. You need to have done that beforehand. I know sometimes being in court is like a family reunion, or like how some people at a funeral becomes a family reunion. And it happens in my family all the time. I'm like, hey, we got to get to the cemetery, but everybody wants to chat. So you can chat after you've handled your business. To my left is the court reporter. Do not place your files or folders or lean up there where she is, because that's her equipment. If you break it, damage it, you will have bought it. And that equipment is $10,000, and we're starting a trial, so she needs her equipment. To my back is the CLO, Vashawn Abrams. Do not turn your back to her. Do not put your items on her desk. Do not sit on her desk. Do not put your papers on her desk. The deputies will bring the inmates from that door. Do not block their line of sight. If something happens where they have to protect me, because that's what my mom wants them to do, and you're in the way, then I will sign an affidavit saying I inform you not to stand in their line of sight. To the left is criminal trial division files. To the right is family violence files. Just pull your file from there, place it on the desk, and they will call you in the order in which they receive your file. When we're on the record, please do not talk behind the court reporter. Just ask the deputies. They'll allow you to move your client down to the end. Do not approach the court, approach the clerks or the coordinator while we're on the record. How do you know we're on the record? Because we will have called the style of the case. There will be a jury coming up here at 11:30 today. So everyone confer with that in mind, because if you want a jury trial in the 187th, we will give you a jury trial. So today is Tuesday. The weather is beautiful outside. Please confer with kindness in your heart and a smile on your face, and everything will go smoothly and perfectly. As Billy Idol would say, it's a nice day for a white wedding. So everyone, please confer. John Coons, I rediscovered Billy Idol.
Nothing wrong with that.
You know what he said in his autobiography? They asked him how he got his name, because you know his real name is not Billy Idol, right? And he said his teacher was mean to him, and his teacher would always say, Billy, you're so idle. And so,
Oh, how funny.
so he's like,
So he took a
Yeah.
word and,
yeah,
repurposed it.
he's like, I'm Billy Idol now.
That's funny.
But I didn't know he was in a bad motorcycle accident and everything.
No.
Yes.
Yeah. Oh,
Oh, yeah.
He was doing really bad stuff.
Oh, he was. And you know, Cradle of Love
Yes.
was his comeback song.
He's on the video.
No,
Because he was still injured, I think.
Yes.
Yeah.
and he said that the guy who was filming it for him charged him next to nothing because he had no money. See, it always takes somebody just to give you that little
Yeah.
hand up.
Well,
But-
and then he was in what, the wedding?
Yes, he was. He made the comeback. I miss the 80s. You know, we don't even have any hair bands anymore.
Well, I miss the age because I had hair.
Okay, you're gonna have to, I'm gonna come to your house and see a photo with you with hair.
Oh, I might have.
Let me see.
So.
Was it a Beatles style? I need to know.
No. We had to, in high school, we couldn't have long hair because you had that color.
Ah.
And no longer, or no further down in your collar. So,
Oh my gosh.
yeah, so I have a picture from college graduation.
Mhm.
The guy who is now the DA of New Orleans, I haven't talked to him in a minute.
Oh, wow.
Yeah. He's an interesting guy because he was running, well, he was city councilman for a long time.
Mhm.
Then he, announced he was in the defense rank.
Mhm.
He announced he was running for the level. And the old DA there, Leo, old school, like. It's Jason. Now Steve's running against Leon. So then Jason's got invited. Yeah, just, he had already sued his accountant, who it turns out wasn't an accountant.
Oh, my gosh.
Basically, already told her,
Yeah.
once he discovered this guy wasn't an accountant.
And wasn't following his taxes.
So went to trial, after he got elected, went to trial, and won.
Oh, wow.
Yeah, so beat the case, but yeah, that's me and Jason. So I have a little bit of hair. You can-
Oh, my gosh.
Yeah.
Okay, you need to send that to me so my mom can see you with hair. Oh, man.
Isn't that funny?
Yeah.
Yeah.
Look at you, always wear glasses.
You know, that I didn't start until my junior year in college.
You know, when I started wearing glasses, I want to say, was it junior high? I think it may have been junior high because I started getting sort of a lazy eye.
Really?
Yes. And then I told my mom about it and the optometrist said she can't see. Yeah. And see, yeah. And so I never knew because I would always sit on the front row because I wanted to see everything. So I'm on the front row, but they were saying, yeah, she's straining her eyes. And so that's how I ended up glasses. Yes. I had to probably be the only person in junior high because my mom was like, my baby is going to have some nice glasses. So I was probably, my mom, of course, we're poor. We don't know we're poor, right? My mom struggled. I think I probably had about 3 or 4 pair of glasses. She's a cutie. And she knows how to pose too. She's doing the head tilt. Oh, wow. She's going to be great. That is so awesome. Oh, I'm doing great. I can't complain. We're closer to Friday than we were yesterday. Look at us, Minnie Rippleton. We're going back down memory lane. This is awesome. Mhm.
So, at the end of the dinner, it was funny because there was all the other vegetable people around me. If he could follow, they would follow. If he smiled, they smiled.
Mhm.
If he flashed, it was really fun.
Yeah.
Because he looked at the start to the right and go around the room, because the faces facing you. Everyone got in the field. Around and come back again. I'm sorry. And so I see. General power. Right.
Oh my gosh. Okay, I'm gonna have to use that. Well, this is the joke I always tell to break the ice. And I will tell you, young children, older people, they all like this joke. This is what I have that I pull out. Why was the strawberry crying? Yes, strawberry. Why was the strawberry crying? Because his mom was in a jam. That's all I have. That's what I have.
Are you serious?
Yeah.
Oh my God.
Oh, that is so awesome.
Oh no.
Well, Mom and I are going to send prayers for her and prayers that she has a great birth. I say celebrate the entire month, but since she's 102, going to be 102, she needs to celebrate the entire year. It just needs to be one party.
Yeah.
All right. Well, when I am 100, you all better celebrate the entire year. It's Stephanie's birthday. Yeah, you don't know. Oh, wow. Yeah.
Do you ever hear anything good about this?
No, ever,
Yeah.
from anyone, never.
Okay, thank you.
Well, I'm having NPR here today, Abby Moreno. I just wanted to check in and then I'm gonna go run back to. Yeah, I just want to let you know.
I will take care of this today. You
Oh,
got
mom
it.
is doing great. She is going to be 79.
All right, thank you.
She's gonna be 79, so it's upcoming in April. What? Oh my gosh, I'm gonna let mom know. Ruth. Mhm. Yes. All right, John Thomas Lyles. Yes, where? Yes, oh, it's behind the line.
Oh, I'm sorry.
That's okay. We're trying to avoid,
No problem.
yes, that's okay. Where's John Lyles?
Okay, they haven't gone back in, Judge.
Oh, well,
Well, I asked, but.
yeah, okay.
Nope.
They're not ready yet. Jerry William Mendoza. And everyone needs to make sure your phone is on silent.
Good morning, Your Honor.
Good morning.
Mom, right side?
Yes. Let me just find him on the docket. All right. All right, on this case, where are we on discovery?
Judge, I believe I have everything. There's two.
All right, just one second. Sorry. Everyone, please whisper. I need you to whisper unless you're before the court. And when you're before the court, please don't whisper. Bring the same energy that you have out in the gallery so that I can hear. All right, yes.
Judge, I have no reason to believe I don't have everything. There's a couple of misdemeanors. I've conferred this morning. We're gonna bring some stuff forward to the DA to perhaps work this case out. So first setting, we're here, and we'll work towards resolution if you can give.
All
us
right,
a-
was an offer tendered?
No, Judge, I think Mr. Hancock wanted me to see whatever he was gonna provide.
That's
I
correct.
considered everything. The other thing, Judge, is that there was some dash cam, but I'm just trying to see whether that exists. I've watched one of the videos, there's 2 videos uploaded, I haven't watched the second. If not, I was just gonna double check with TCSO.
All right, could I have a reset form, please? You all are gonna come back on, and could you call to have someone come down to complete the resets? You're gonna come back on April 22nd. You all gonna need to confer off docket.
Yes,
All right, I'll give you a reset form, and once you are sign the reset form, you excuse.
Thank you, Judge.
All right.
Check back and see. Or-
Oh, no, I'm gonna give it to you right now.
Oh, thank you, Your Honor.
And counsel, this is gonna be put on the docket as a jury trial.
Thank you, Your Honor.
I know, sometimes people want quickness, and we try. I'm sure there'll be other cases that are ahead of you.
Morning, Judge. How you
Morning,
doing?
all right.
It's Zachary Gilmore. Yes, ma'am.
Zachary Gilmore?
I don't know what page he's on your document, Judge.
Oh, I have him on page 18. All right, what is happening with this case? All discovery?
I'm still reviewing the discovery, Judge. I think he's a first setting. I will let you know if we can have another setting to confer, if
All right.
possible.
Do you think you received all the discovery?
I'm still going through it.
Okay,
I know there are some medical records that I'm looking at and also some body worn cameras that I have not seen at the scene. But they're there.
all right. And were you able to tender an offer?
A preliminary offer, given just the kind of earliness of confirming with the council, but yes, there has been an offer placed over to Defense Fund.
All right. Well, I'll recall you all back on April 22nd. I will not be here because that's my mom's birthday, but Judge Angelini will be. All right. Thank you so much for dressing appropriately for court. Could I have a reset form, please?
Thank you, Judge. We
You're
appreciate it.
Have a seat back.
Thank you. And I'll give you the reset form.
Okay. Going this morning. I'm okay.
All right, thank you. Once you sign that, you're excused.
Do you need my client to sign also, Judge?
Yes, please. They're moving towards paperless, but they haven't told defendants yet. All right, Edwin Rosario Montes.
Morning, Judge.
Good morning. How are you doing today?
We're doing good.
All right. Let me just pull this up. My computer is being slow today.
Oh, second to last is compliance. Right?
All right. So you know why you're here?
Yes, ma'am, I do.
Why are you here?
Because of the field visit and because of my work.
Yes. So why is it that you say you work, but you've never submitted to them a pay stub or a paycheck or anything?
So ma'am, before I got sentenced to come see you, she told me to bring paperwork like the day that she sentenced me to come see you, and I brought it to her, and she still sentenced me to come see you. I don't understand why I brought her.
Oh, because you're not doing, because here's the thing. Why is it that I have to have you come in here when you know you're supposed to be doing what you're supposed to be doing? For example, the field team, the report I have that you've been employed for over a month, but they don't know the name of your employer, which you know what that means? That means that you didn't give it to them and they asked for it. They say that you hadn't received a paycheck. And I know how some jobs are. When my mom first started working, they would call it a paycheck in the hole. You wouldn't get paid immediately, but that's not your case. So why do we have to have a meeting for you to turn over documentation that you're actually employed?
So with my employment, before I came here, I gave her 3 of my recent pay stubs. I'm not sure why she didn't put it in. The same day that she told me to come in and bring my paperwork in is the same day that she told me.
But why do we have to get to this point? That's what I'm trying to understand, because the field team visited you, according to this, from February 2024, before February 2024, they've been asking for proof of employment. So why do we have to have you come into court for you to start saying, oh, this is important?
It just took me a little bit to get a job, but I was able to get it. And like I said, the day that she told me to bring the paperwork in, I was able to provide it, but she still
Who lives with you at your home?
It's just me and my roommate, but right now I'm about to move back to my mom's house.
All right, what is Hornitos Tequila?
It's just a drink. I live at my roommate's house. It's an apartment,
And how many bedrooms?
just two.
So why is your apartment in disrepair?
I'm sorry.
Why is the apartment in disrepair?
It's just a little messy.
No, I mean, they're saying that it's not just a little messy. What I'm reading is not good. Have you talked to a counselor? Do you need a counselor? What's going on?
I mean, that would be kind of helpful.
Well, no, I mean, what's going on in your life? Why is your apartment the way it is?
I really don't have an answer. It's just messy.
Do y'all have dogs at that?
Yeah, we do have a dog.
All right, just one?
Yes, ma'am.
And how old is that dog?
About a year.
All right, and what type of dog is it?
She's an American bully.
All right. So they're saying there's problems with that apartment based upon, I'm assuming the pet you have, because they're saying it's drenched in urine and feces. So that means somebody is not picking up after the dog.
Not gonna lie, it probably smells a little bad, but it's not like it's not everywhere, but it does smell a little bad.
All right, is this your dog or your roommate's dog?
It's both of our dogs. It's mainly his, but it's both of our dogs.
All right, and you say you're going to go live with your mom?
Yes, ma'am.
Have you talked to your mom? Does she want you there?
Yes, ma'am. For a little bit, at least a month until I'm able to get my own place. I'm looking to get my own studio apartment for now.
Mhm.
I've been looking at it. They're about $600. So they're a little bit more affordable than the apartment that I'm staying at right now.
All right, if you're drug tested today, what are the results going to be?
A negative, like my other drug test.
All right, can we do a drug test today? Yes. All right, let's see what the drug test is, and then I'll tell you what we're gonna do about this situation.
This one?
All right, just have a seat.
Sorry.
Ms. Abrams, you want me to take up the others?
Yes, Judge, this is what-
Benicia Davis?
Morning,
Good morning. Just one moment. All right. So do you want to just do your time at the Bear County Jail and be done with this case?
No, I do not.
Then why do you keep skipping tests?
Well, at first it was because it's a certain way you have to do it. When you plug it in, you wait 60 seconds and then you have to wait an additional 90 seconds. So I wasn't plugging in a lot because of my kids, so they wouldn't get to it.
You
and
mean
then I
because of your
plugged it in.
children?
Huh?
You mean because of your children, kids
Yeah.
or baby goats?
No, my children.
All right, so what's going on with your children?
Well, they okay. I just had a baby, October 18th. We just currently moved out of our apartment.
All right, who is we?
Me, my 3 kids.
Children.
My children, yeah, I'm
Yep.
sorry. But yeah, me and my children just moved out, January 1st, back to my mom. So I'm currently looking for a bigger house and, still looking for employment as well, since I just had a baby, so it's kind of hard.
So where's the father? And this is just me asking because I'm
He's
curious. All
not around. He went back to Chicago.
right, so why don't people make plans and do some research before they consider having a child with somebody?
I mean,
Are we
did
just
have
out here?
plans.
Are we just out here having children?
No, we actually did have plans. He who got the house, the furniture and everything, we just didn't work out. So I packed up and I got a U-Haul truck and I moved my stuff out and went back to my mom's and he left.
All right, here's the thing. If you skip another test, a motion to revoke is going to be filed. So it's probably in your children's best interest that you stay with your mother until this probation is done, because let me just tell you what will happen. If a motion to revoke is filed with you and you're living by yourself with your children, you know what's going to end up happening? CPS is going to get called. And when CPS gets called, they're going to take your children. Then once they take your children, what will end up happening is they'll see if there's a relative who's willing to take all three. Maybe your mom will say, you know what, I'll step up to the plate, I'll take all three. Or maybe she may say, you know what, I can't handle 3 children, I'll take 1. And then your children will be spread out to different people, or either they will be in the foster system and they may be spread out in the foster system with 3 different people. How old are your children?
11, 8, 7, and 4 months.
All right, so usually what I can tell you in Child Protective Services cases, everybody wants the baby. And you know why they want the baby? Because they feel as though maybe the baby hasn't suffered too much trauma because they're just a baby. So everybody wants the baby. The 11-year-old, usually in the foster care system, people are like, 11-year-old is too old. So what will end up happening if you don't get your act together is that there's a potential for your children being placed in the foster care system and being split up. So you're going to be living with your mother. You're not moving from your mother's home until this case is done. Do you understand?
When would this case be done, Your Honor?
You'll talk to probation about that. So you're going to live with your mom. And moving around from place to place is not good for children anyway. Ms. Abrams, she's going to stay with her mom. If there's another skipped test, what's going to end up happening is just file a motion to revoke. And if you're drug tested today, what are the results going to be?
It's always been negative.
All right. So, and we'll do a drug test today for her. Do you have any questions about anything?
I mean, I do. I feel like I never, since I had the breathalyzer, I never, not once missed. I always blow 3 times a day. If anything, I'm late, but as far as missing, I always blew 3 times a day. So I don't understand why.
From January 5th, 2024 to February 6th, 2024, there have been 16 skip tests. So that's where we are.
It's impossible.
Well, that's what I have.
And Judge, a skip test is a late test, just to make clarification for the court.
Yes.
So even if you're 5 minutes late, they consider that as a skip.
Oh, okay.
Yes.
Okay.
So you're going to live with your mom? Get her dress for her mom? That's where you're going to live until this probation is completed. You're not going to skip any more tests. If you skip another test, we're not going to have this conversation. Just file a motion to revoke. And if it's in proper order, I'm going to sign it. And it's better for you to be at your mother's house with your children if a motion to revoke is filed than on your own. Do you understand?
Yes, I do.
All right, thank you. Louis Herrera.
I talked to the ADA, he said that was fine.
Hello, Mr. Herrera. Let me, here we are. It did. Just 1 second. My computer did something weird. Yes. Oh, thank you. All right. Why is it taking you forever to provide your list of medications?
She didn't notify me that I came out positive. I had reported to her. She
Well,
didn't.
no, let's stop right there. When the probation officer says, I want a list of your medications, it doesn't matter whether you came out positive or not. They want a list of your medications. I don't know what people don't understand. Let me explain to you something about probation. Probation is what people call being on paper. That means that your life is not your own. And you know why your life is not your own? Because when you're on probation, it's a contract. And if you violate the contract, you're looking at going to prison. So really, probation owes you no explanation when they're asking for documentation for something. So whether you had a positive UA or not, they are looking at prison. Do you understand? And when they tell you, I want your prescriptions, you need to provide your prescriptions. Do you understand?
ma'am.
If you do not provide your prescriptions, if you do not provide what your probation officer is asking for when requested, guess what? We're not going to have this conversation anymore. What's going to end up happening is the motion to revoke is going to be filed. Do you understand?
Yes, ma'am.
And do you understand if a motion to revoke is filed, you're looking at potentially 10 years in the prison?
Yes, ma'am.
So your actions, you need to start asking yourself, when you don't want to do something that probation is asking of you, you need to ask yourself, is this worth potentially going to prison for 10 years? If the answer is yes, then don't do it. And guess what will end up happening? A motion to revoke will be filed. When a probation officer asks you for information, you give it. If you feel as though probation doesn't deserve to know this, you still give it, and then you come to court and you speak to Ms. Abrams or you speak to me and say, hey, probation asked for this. I gave it to them, but I don't understand why they want it. No one will explain it to me. Do you understand?
Yes, ma'am.
And I see a list of medications that you're on. So some of these medications should fall by the wayside because the hydrocodone, that's supposed to be taken for severe cough. And I see it was refilled in November 2023. Are you still suffering from a severe cough?
No.
Okay, at some point that's supposed to end. Do you understand?
Yes, ma'am.
And then the ibuprofen for moderate pain, that's not supposed to be every day. I'm not a doctor, but I do know that if you take too much ibuprofen, that messes with your kidneys. So that's not supposed to be an everyday thing. And this is me as a non-doctor. Whenever a doctor wants to give people medications, and I've had family members who have medications for certain things, if you're getting ibuprofen for pain, and I see 3 times you've been given it, guess what? You need to find out what the pain is for, because ibuprofen, it doesn't cure the pain. All of this stuff just masks the problem. The problem is still there, but you just don't feel it. So you probably need to start talking to your doctor and asking what's going on if you're on these meds. Do you understand? Now, if you're drug tested today, are you going to be positive for any of this? Are you still taking hydrocodone?
No.
Okay. Are you still taking ibuprofen?
No.
When's the last time you took those medications?
Last month?
All right, so you should be negative. Have you taken anything?
No.
All right, so when you're drug tested today, is it going to be negative?
Yes, ma'am.
All right, so we're going to do a drug test today. Is there anything else that you're having issues with?
No, ma'am.
Anything? Now's the time to tell me.
No.
All right, so last time it says that you were positive for opiates at the beginning of February. So you should be negative, okay? So you're going to be negative. You haven't used anything.
No.
All right, just have a seat. We will do that. All right, thank you. Okay. Thank you. Mr. Savaglio, is he here?
He's a judge, yes, ma'am.
All right, come forward, sir. Hello. Good morning. All right, your case has been dismissed. I don't know what caused you to be here, but go forth and live life as a great citizen, okay?
Outstanding. Thank you, Your Honor.
All right, thank you. Have a good day.
Thank you, Judge.
Can I see the file on Savaglio, please? It's Kevin. He's the only Savaglio on the docket. Salvaggio. Miss Abrams, do we have people who need water?
Yes, Judge.
Okay. Yes, he's on the docket. He's on page 17. Thank you. Yes. Thank you.
Right there. Judge,
Yes.
Mr. Rodriguez. Were released last night. He just got.
Oh, hi, Mr. Rodriguez. All right, you look better out of orange. All right, just have a seat. Your attorney will be here. Okay. Oh, no, I will. Sure. All right, who is here on John Lyles? All right, Mr. Lyles, come down. All right, Mr. Lyles is scheduled for jury trial.
Yes, Your Honor. I'm here for Tony Hernandez, the attorney of record judge. He is in Del Rio in felony court this morning. And I just wanted to let the court know that that's where he's at.
All right, is he in Del Rio in felony court for jury trial?
No, not for jury trial, but he's there on appearance.
All right, tell him his client is here on trial.
He doesn't know that, Judge. He just wanted to let the court know that there's a possibility he might not make it back till late this afternoon.
Okay, tell him he needs to make it back because this is a jury case.
Okay.
All right. And it's tell him his client is dressed for trial in a Nightmare from Elm Street t-shirt. Okay,
Let's see.
all right, okay, thank you. All right.
I haven't seen that.
They're not ready on that one. Did someone call for the interpreter?
Yes, ma'am, I did. The attorney's already spoken to me.
Yes. All right, which case is this? That needs the interpreter.
But your people said that he has. The one that said- I know.
Brian Maldonado or Rita? Who's the attorney?
Albert Garcia, Your Honor.
Thank you. All right, so this is scheduled for a jury trial today.
That is correct, Judge.
All right. Then we'll be here for jury at 11:30. We'll have a jury brought up.
Okay.
Okay.
Judge.
All right. Any questions? No. All right, thank you.
Judge.
You're welcome.
Absolutely.
Maybe excuse me.
Yes, always great seeing you. Jose Carmona? All right, and counsel, you're on this side, your client's in the middle. It's a felon in possession.
Yes, Your Honor. On the CTD side, but while Hank is absconded, I can provide
Okay,
potential clarity.
all right. So do you have all of the discovery?
I think so, Your Honor. We've gotten some recent pin packet information that doesn't look correct. We're investigating that. We have conferred with CTD. And there is also an unindicted family violence case that is being reviewed. And I have met with the Family Violence Department regarding that. And we're trying to get a kind of a global resolution.
All right, and are you on the family violence case as well?
Yes.
All right. When do y'all think you'll have information for him on the family violence case?
Well, I know that counsel is going to reach out to the intake attorney, and I've just recently made notes in the system for the intake attorney as well. So as soon as counsel has that opportunity, it shouldn't be longer than maybe a couple weeks at most, wherein a global offer would be able to be tendered to counsel, Your Honor.
All right. Ms. Ferguson, put this on April 8th.
Yes.
All right, we'll come back on April 8th.
Thank you, Judge.
All right, once you sign the reset form, you're excused.
Thank you, Your Honor.
Yes. Jessica Desamito. Where are you? All right, just raise your hand, have a seat. Jesus Garza. And he's in federal custody, correct?
Correct.
All right, can I see the file on Jesus Garza, please? Okay.
And Judge, just to give you an update on it, he's supposed to be finished in February.
Everyone, please whisper.
He's supposed to be finished in February of the sentencing. I believe that Suzanne told me that he has been sentenced. I sent an email this morning to my clerk just to find out if he's in transit or where. So I
It should be
imagine it's gonna
soon.
be that far off.
All right, and I'm assuming the federal case is not going to take care of these.
It just seems like our policy now is not to do what we've done before.
All right, so Norma, he needs to be bench warranted.
I know he can get credit, but I'm saying.
All right, well, do the writ.
Oh, yeah.
All right, better get done. Here's the thing, bring him back on, bring him here on April 1st.
That'd be fine. Judge.
Okay,
Thank you, Judge. May I be excused?
yes.
Thank you.
Larry Holmes?
Judge, may I approach on that?
Yes.
File
Okay, behind the line. You're in trial?
in the 186.
All right, where's your client?
He's in custody.
All right,
See if we can get him sent.
all right.
I've spoken to the state. And they're still looking at sentence.
Just one moment. We'll call it back April 1st. All right. Norma, Larry Holmes is coming back April 1st. Deputy Mejia, could you bring Mr. Holmes? Is he downstairs? Oh, well, when he comes up, I'll let him know. All right, thank you.
The Larry Holmes?
Yes, you know what? Mejia doesn't know who that is. Next, he's gonna tell me he doesn't know who Hector Camacho is. Yes.
Yeah, well, I think he's in. Like last time he checked, he was in custody. Almost at 4 months.
Yes. Mhm. Okay. Yes. Ms. Abrams, are you ready for probation?
Yes, sir.
All right, court is calling 2024 CR 2435, State of Texas versus Raymond Isaac Uribe. Could I have the parties approach and announce for the record for the state
Zach Dunn for the state, Your Honor.
defense?
John Finch for Mr. Uribe.
And are you Mr. Uribe?
Yes, ma'am. Yes, Your Honor.
All right, listed on the docket is Megan Enriquez.
That's correct, Judge. I'm filling in for her right now. She's downstairs in the 175th, I think.
All right, any objections, Mr. Uribe, to this attorney standing in for purposes of the plea? Counsel, have you received all the discovery? Did you review it with your client?
We have, Your Honor.
And there are no applications?
No, Your Honor.
Mr. Uribe, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are waiving the repeater enhancement, Your Honor.
Any objection?
No, we're very grateful. Actually, they're waiving the habitual, so.
All right, Mr.
Oh, it's file stand habitual. Okay. Okay.
All right, when y'all do the discussions off the record from people from the back, court reporter is still taking it down. So,
And just to confirm, Your Honor, it is a repeat offender that the state is waiving.
all right,
No objection to that.
all right. All right, Mr. Uribe, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review this document with your attorney? Did you understand it? Did you sign it
Yes,
in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with violation, sex offender registration, or previous conviction?
Yes, Your Honor.
Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine.
Yes, Your Honor.
If you have a plea with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, The fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes and yes.
Mr. Uribe, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No.
Satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 3 years in the prison. There are no applications. They will take into consideration 2024 CR 2435. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Judge, can we confirm that clause number? 2435. Okay, yes, thank you.
Next, I'm showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Just one moment, off the record. Excuse me. Can I get the correct file on this case? No, there's an issue here. So here's the issue. 2435 is what I have, and that's that was the issue with the true bill of indictment, because that's for the possession less than a gram case.
Okay.
So I need the file for 265.
That's why I got confused on the case numbers. When you said the TIC number, I thought, well, that's the number of the case that you called.
So to correct the record, the cause number that you're pleading under is 2024 CR 0265. Do you understand?
Yes, Your Honor.
And that's what we did the paperwork.
Then to the offense as charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
TNF first states one in attachments, Your Honor.
Any objections?
No, Your Honor.
And also to clear the record, Mr. Uribe, I'm showing you the indictment under this cause number. Did you review that indictment with your attorney? Did you understand it?
Yes.
Right. And counsel, you are waiving the reading of the indictment in that case?
We are, Judge.
All right, Mr. Uribe, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, sir.
And counsel, you may continue to confer, state.
Thank you, Judge.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor. I've explained to him that he needs to be very careful when he gets out, because he will be a habitual offender. with the mandatory minimum 25 years, so he tells me he has a job lined up when he does get out eventually. Unfortunately, I think he's just kind of caught in this cycle of homelessness and not being able to register on time, sort of stuff. So we would just ask him to follow.
All right, the court will sentence you to the 3 years in the prison, give you credit for any time served. Take in consideration 2024 CR 2432, and there's to be chapter 62 registration. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we're off the record. Could I get a copy of the dismissal?
I have it, Your Honor, right?
All right, thank you. All right, Mr. Uribe, I understand that it's hard to find housing with your charges. I understand that may result in you being homeless, but you must report, because the biggest thing is people not knowing where you are. You understand?
Yes.
All right, good luck to you.
Thank you, Judge.
You're welcome. John?
My arms are long, but they're not that long.
Thank you.
Appreciate it.
Oh, I don't know. I didn't have that on my docket.
Oh, I guess. People were here for his guidance or something.
There's one person, he's here, that's Charles Bond. The other people, they didn't answer up, they must have came in late. So I didn't have them. Joseph Balboa. We're filled with Larry Holmes Balboa.
Rocky.
Yes, come on down, Mr. Balboa. Denise, why is your client not in Philadelphia?
Ready to Texas, man.
How
are you doing?
All right, how are you doing?
Okay, man.
All right, see, the thing is that we've had a lot of people in court today with boxers' names, and the young people have no idea what references.
My son's name is Joseph Rocky Balboa.
What?
Yeah, and they knew after that.
Okay,
Yes, man.
well, you gotta go to Philadelphia. All right, what's happening with this case?
Well, this is a new case that hasn't been indicted yet. That's part of NPR. My issue is that I have in the 457, have a jury that's supposed to start around 10-ish.
Okay,
So I need. to get
oh, you
that.
need to go.
So
All right, so when do you all think you're gonna have this information for him on the new case? I think it's no, it's the trial division.
Are you listed on that one? The, do you just?
Norma, can you make sure that,
It's not.
can you make sure that he's on the new number one, Mr. Cox? On Balboa? And then we'll reset this so you can get to your jury trial.
Yes, ma'am.
All right, so Ms. Ferguson, on this case, reset this for late March. No, this is the motion to revoke.
Oh, I'm sorry. I thought I heard this.
No. All right, so we're gonna come back on March 28th. And if your attorney finishes with this trial sooner and wants you brought over sooner, we'll do that, all right?
Yes, ma'am. Thank you, ma'am.
Ms. Abrams? Balboa is coming back on March 28th. His attorney is in a jury trial. And if you'll make sure that he's on the new number one. Larry Holmes, if you'll come down, sir. Mr. Holmes, your case is being recalled for April 1st. Your attorney is actually in a jury trial in another court. So if he finishes his jury trial earlier, we'll bring you back, all right? All right, thank you. Christopher Rodriguez. Who's the attorney for Christopher Rodriguez? All right, where's Christopher
In
Rodriguez?
custody, Your Honor.
All right, come down. Okay. All right, so an offer is due. Has an offer been tendered?
Yes, Your Honor.
Yes, Your Honor.
All right, how old are you, sir?
34, ma'am.
All right, Ms. Ferguson. Recall this case at the end of March. All right, we're coming back on March 28th. That's your plea deadline date. At that time, you need to let the court know whether or not you're accepting the state's offer. If you choose not to accept the offer, or if no agreement is reached, then your plea deadline date will have expired, and the court will not consider any plea bargain agreements without good cause. Otherwise, you have the plea open to the court. Do you understand?
What's that mean?
I'll explain that to him, Your Honor.
All right, thank you. Is there anything else? All right, thank you.
Hold up. So, number one, Larry Cole. And leave it. I'm not gonna do the great guys for you. Yeah. Just have a seat. I'll come get you. This is Mark's duties.
Have a seat, have a seat. Have a seat.
Mark, something. No, when it's coming back.
And Norma, we need a jury up here by 11:30. Louis, oh, are we still waiting on Mr. Herrera and?
Yes, Judge.
All right.
You good? No.
Oh.
Okay.
Christopher Black.
Christopher Black.
He's on Zoom, Judge.
Yes. All right, Mr. Black, you need to show your video. And unmute. Court is calling 2021 CR 11535, State of Texas versus Christopher Darrell Black. Can I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Kelly Biddle.
And are you Mr. Black?
Yes, I am.
All right, any objection to Mr. Black appearing by video, state?
I tell you, Your Honor.
All right, defense has filed a motion for early termination. State, have you had a chance to review that?
We have,
And State, are you opposed?
we are.
All right. State, why are you opposed?
I think just for three critical reasons, Your Honor. One, just the severity of the injury, just the nature of, it's almost a foot long, if you will, the scrape to the back. This probationer has only served about fourth of their total term. And we don't believe, and they have a short, if you will, criminal history, not family violence or violence related, but they're in a criminal history. So for those three reasons, the state is opposed, Your Honor.
All right, defense.
Judge, Mr. Black has completed everything that the court has asked of him. I would disagree with Mr. Dunn's characterization of the injuries. He pushed his stepfather-in-law, and the man fell backwards into a credenza and scratched his back. He's had no contact with the complainant. He's done everything the court's asked of him. And the purpose of probation is rehabilitation. I think Mr. Black is a prime example for why he should be allowed early termination, and to keep him on probation longer just for not a really good reason from the state, just to keep him on probation. It just works counterintuitive to what this court is hoping to accomplish with probation.
All right. Anything else from either side?
Just to quick clarify, I'm not sure it's counterintuitive to hold people to the term that they've agreed to. Again, we're at almost less than a fourth of the total term. And the state would just like to, again, stand by the classification and characterization of the injury to the back. It's nearly the whole left side, if you will, give or take a couple inches on either side. So not a small scrape or a paper cut, but certainly an injury of relative significance, if you will.
This is a misdemeanor, other than the fact that the plaintiff is 68.
All right, this is what the court is going to do. He's been on probation since February 3rd, 2023. You can resubmit your application or your request in February. The motion for early termination at this time is denied.
Can he be allowed to report quarterly?
All right. Any objections to him reporting quarterly or by mail?
No, Your Honor.
Because my understanding, he's in Cameron County, is that correct? All right. Is there any objection to him reporting by mail?
No, Your Honor, no objection.
I'll allow him to report by mail. I think that gives him something for having completed everything early. Mr. Black, we can go off the record.
Yes, sir.
All right. You just need to have more time on probation. Sometimes people race through things. It's sort of similar to when people are in treatment and they race through all of the steps. And then they say, I've done everything, let me off. So I do recognize that you have completed everything, but come back to me in February. And if everything is still the same and there are no violations, I'll strongly consider early termination. You understand?
Yes, Your Honor.
All right, thank you.
Will the court waive the remaining supervisory fees until next year?
No.
Okay.
Supervisory fees are how probation officers are paid their salaries. So I do not weigh those. If there is something else, maybe fines or anything of that nature, I will. But supervisory fees, no. And if someone would like supervisory fees waived, if you'll present a motion, I will strongly consider it. But for now, in this case, my understanding, the only fees he has to pay are supervisory fees. Are there other fees that he has to pay other than supervisory?
I don't believe so.
All right. So if you want to present something that's saying for some reason his finances are such that he cannot pay supervisory fees, then I'll review that. But just asking for it, no. And I'll allow him to report by mail. Is there anything else?
That's it.
All right, thank you.
Thank you, Judge.
All right, thank you, Mr. Black. Keep up the good work.
Yes, ma'am. Thank you.
All right. right, and just off the record, have you had any contact with your mother or no?
No, ma'am, Your Honor. Since moving down to Brownsville, we've had no contact with family, no one whatsoever. Just been, I reinvented my career, support my family.
All right, all right. Thank you so much.
Thank you. Thank you.
That's fine.
All right, you're excused, Mr. Black.
I don't want to keep one thing. I know that's that. In a box. So. That's one. Yeah. I think that discussion is one where I was saying. It's not. No, it never was. I mean, it's like. You know, I'm sure you're like, I really like talk to that. So I just sort of. I think you're right. I did. For sure.
So has a chat been going?
She very much wants to. She doesn't want to become a novice. She doesn't want to stop her.
Roberto Rosales. Hello.
Judge, he was a little late, so it looks like he's here now. So I was just gonna let the court know, but
Yeah, and so here's the problem. I'm gonna check to see if he was a little late because he was a little late last time and I admonished him not to come in. So let me check. Yep, you were late again today. You're gonna be spending the day with us.
I've been here since 9 o'clock.
No, I called you and you didn't respond to the docket.
I didn't hear. I might have been in the restroom. I've been here for like 45 minutes, but it's okay. I understand.
So yes, what is happening with this case?
I'm gonna confer with the state judge.
All right, so have a seat. Deputy Mejia, Mr. Rosales is going to be spending the day with us today. But he can, he's not in custody, but he is not to leave the courtroom. They are conferring on that. Paul Bell. And then after Mr. Bell, it will be Mr. Klein.
I'm sorry.
All right, so where are we on Mr. Bell?
Your Honor, we received an updated offer yesterday. The state has changed their position. For that reason, we are applying to the Veterans Treatment Court. We think that would be a good place for him. He did serve for 20 years.
All right, so here's the thing with Veterans Treatment Court.
Yes, Your Honor.
What I'm understanding is it is taking 3 months for Veterans Treatment Court. So do you have your DD 214?
Yes, ma'am.
All right, so. And what is with the new case?
No new case, just new discovery.
Well, there's a checkbox here that says new case 2024. Okay,
Your Honor, that's just the case number for this case. I might
Okay.
need to scratch that part out.
all right,
Yeah.
thank you. All right, so this is what we are going to do. I'm resetting this and I'm resetting it for a month. And if he's not in Veterans Treatment Court and they haven't set it, then he's not going to Veterans Treatment Court.
Okay, Your Honor.
Felony drug court, the other treatment courts, they can get you in no later than 2 weeks and let you know whether or not you're accepted or not. Veterans Treatment Court needs to streamline their process. I don't know why it's so difficult for people who've served in the military to get in Veterans Treatment Court. I don't know why they don't help veterans get their DD 214 when they need it. These are just my thoughts. So we're going to call this back and we're calling it back on April 1st. And he needs to have been reviewed by Veterans Treatment Court. Veterans Treatment Court needs to have accepted him by that time. Otherwise, he's not going to Veterans Treatment Court. We'll figure something else out.
Yes, Your Honor.
All right, Ms. Ferguson or Mr. Bell, can you recall this for April 1st? And thank you for dressing appropriately for court.
Yes, ma'am.
All right, once you get the reset form, you're excused.
Thank you, Your Honor. Thank you, Judge.
You're welcome. Okay, thank you. Down. And counsel, Mr. Bell was late. He cannot be late again.
He was on a phone call, Your Honor, he was present, but I'll make sure he's inside at 9 o'clock, Your Honor.
All right, Mr. Bonk on Michael Rodriguez.
Yes, Judge, he's present.
Yes.
He's not feeling well. We matched him and put him in the hall.
Okay,
But I conferred with the state. He's pre-indictment, so if we can just, I guess, reset him until he's indicted.
oh, well, what will end up happening once he's indicted, then you'll get notice.
That's fine.
Okay.
One of the court, no, he's present, but we've put him outside.
Oh, no,
because of his
he
health.
was on time.
Okay.
All right.
He be excused.
Yes.
Okay, thank you.
All right, thank you.
And I'll also ask the court to consider this on a separate matter. That case was dismissed. You had waived the fees, but somehow it didn't get entered into the system, so as he accrued some fees, I'd like to then.
Okay, let me make some phone calls about this and we'll take care of it.
Thank you.
You're welcome.
I'm gonna go excuse him, then I've got another matter, I'll do that.
Thank you. Robert Klein.
Judge, I'm not even going back to the table. I'm just gonna.
You're just
plant
gonna
myself
stay there?
Here.
We need to put a stand there for you to just have your files there. All right, let me pull this up. All right, so what is happening with this case? There's an motion to revoke?
Yes, Your Honor. So I believe, of course, before we go on the record, counsel and I have spoken. And this probationer's term is going to be up in December. They've had extensive kind of medical history that kind of elucidates the potential reasons and varieties for why they've been able to comply with some of the probationer's requests and kind of meeting those requirements.
So are you withdrawing?
Well, we were hoping to have him plead true to the technical and just term unsat, if that's a possibility, or if it's easier for the court process, we're happy to withdraw it as well, whatever's the most streamlined approach, Your Honor.
All right, so he's doing fine now. Did y'all confer with probation?
We did briefly speak with probation, Your Honor, yes.
All right, if you all don't want to withdraw the motion because of his medical health that occurred, you can, but I'm not early terminating him because, and let me explain why you're not getting early termination from the court. Because according to the allegations in the motion, it's alleged that you were using alcohol. That's a problem. It's alleged that you have invalid samples that have been given. The reporting, if you're in the hospital during those months, I understand that. But you were not doing well on probation before you had the hospital issues. So I'm not inclined to terminate. He's going to be on probation until this probation ends. This is a stalking case.
Absolutely, Judge. So we will go ahead and do the withdrawal, Your Honor.
I would point out, if I may,
Yes.
that the state has been in contact with the original complainant.
Mm-hmm.
And she's had no contact with Mr. Klein for years.
Okay.
I guess the extent of the probation, I don't know how long.
No, counsel is exactly right, Your Honor. Of course, all the things that Your Honor has laid out in terms of the non-compliance, it's absolutely, that's there, but I know the court had asked the state to reach out to the complainant just to kind of provide a full picture for the court. And just like counsel stated, in the past about 3.5 years, the complainant was able to confirm that there has been no contact.
All right. So, I mean, my thing still stands. The motion can be withdrawn, but he hasn't shown me anything on probation that he's successfully done anything.
Yes, Your Honor.
So you're going to be on probation until this probation ends.
Can we discuss amending any of the conditions, because he has a very difficult time making appearances as required.
All right. I had him down for reporting by Zoom.
I'm sorry?
I had him reporting for Zoom. He hasn't even done that. So that is as low as it's going to go.
All this time, Judge, these difficulties he's had. He's been in the, I've seen him at least 6 times myself personally in the hospital. He's had an extensive, we provided to the state 1,200 pages.
All right,
of
so
medical.
here's my question though. Has he been continuously in the hospital September, October, November, December 2023? You were in the hospital for all of those months and never left.
Most of the time, yes, sir.
All right, so then the answer to that is no. So at some point, you should have been able to report by Zoom. Zoom is just you from wherever on your computer. I've had people appear by Zoom from their hospital beds. I don't request them to do that, but they are just so intent of, nope, I don't want anybody to say that I haven't been following through. So they have Zoomed in from their hospital. You have Zoomed in from nowhere.
Zoomed in from the hospital. I've been in the hospital.
All right, so he said he Zoomed in from the hospital. He still missed all these times reporting. So that's where we are. I'm not going to allow you to terminate UNSAT. You can withdraw the motion because you are saying he's in the hospital, but he's going to report. He needs to do what's required of him on probation.
Absolutely, Judge.
And I understand your medical issues. I understand that you've had an amputation, but I mean, having an amputation, I sympathize with you. I've watched a lot of documentaries on it, but I know that's not the same as having had it happen to you. But that doesn't mean you don't get to do probation.
Can he continue to report by Zoom then?
Are you okay with him reporting by Zoom?
Yes, Judge.
All right, he can report by Zoom.
All right, I'll make sure that he does, and I know he will. Judge.
All right, thank you. I appreciate it. I know you'll make that happen, Judge Longoria. All right, so they'll withdraw the motion and then he's to report by Zoom. And I already ordered that previously.
Thank you, Judge.
Thank you.
May we be excused?
Once he speaks with probation, because they have new conditions for him to sign.
Thank you, Judge.
You're welcome.
You have a.
All right, are we ready on Ruiz? Oh, I'll let you all finish talking.
She is Judge. I wish she was talking. I don't know if she's ready.
Okay.
Ready?
I'm ready to ask you to tell us.
Well, if you want to continue to confer about the other issues, then I'll hear your motion.
Now,
I said I can, if you want to continue to confer with him, you can continue to confer with him now. And then I'll hear your motions because we have a jury trial that's starting at 11:30. So you may want to talk to him now and then I'll hear your argument on the motion. Antonio Rios. Okay, yes.
Positive for methadone.
All right. Thank you. All right, are you ready to proceed, Vashon?
yes,
All right, Louis Herrera. All right, why would I ask you if you're going to be positive for something? You said you would be positive for nothing.
I didn't even.
But you're positive for methadone. How can you not know?
Know what that is.
All right, Miss Abrams.
I'm telling her, I take Benadryl, like melatonin to fall asleep, but I don't know.
You can't be using any medication that is not prescribed to you while you're on probation, and methadone is a drug that has to be prescribed. So has he had a TAP evaluation?
TAP evaluation, no, Judge.
All right, what we're going to do with him is we're going to do the UA hotline and we'll do the TAP evaluation out of custody. And I'm going to want 90 meetings from him in 90 days. So you're going to do 90 sober meetings for the court and you're going to do those in 90 days. Sober support meetings are the AA meetings, NA meetings. They're all over town. You understand? And
The
you're gonna,
AA meetings.
they're similar to AA meetings, but they just call them sober support meetings now. So you're going to do 90 of those in 90 days. So every day you need to be going to a meeting. We're going to do the UA hotline. Has he previously been, Ms. Abrams, was he ever previously referred to felony drug court? All right, we're going to do a referral to felony drug court as well. And I know you're probably saying to yourself, I cannot believe the judge is doing that to me. This is a problem. You know, I don't know where I got this methadone. Here's the thing, I'm trying to help you be successful in probation. Testing positive for methadone and you don't have a prescription, guess what? That's a violation of your probation. And for that violation, you could be sent to the prison for up to 10 years in prison. You understand?
Yes, ma'am.
So what's going to end up happening is they're going to get a TAP evaluation for you done. You're going to be referred to felony drug court. Do not miss an appointment with felony drug court. You understand?
What is that, ma'am?
Probation is going to give you information on that, but it is one of the treatment courts, and they'll be able to help you with your drug or alcohol problem, and you need to be 100% honest with them. You understand? So don't go in front of them saying, I don't know where I got methadone. Do you understand?
Yes, ma'am.
And when you leave here today, do not celebrate, yay, I didn't go to prison, because the last time you use may be the last time you use. Do you have a mom or family members who are currently alive? Do you have family members?
Just my mother-in-law and father-in-law.
All right. You don't want them to have to identify your body because you got a bad batch of drugs. You understand?
Yes.
All right. So just have a seat. Probation is going to go over your new conditions. All right. Edwin Rosario Montes. Oh, you haven't submitted your UA? Let me just tell you right now, you can sit there and drink all the water you want. This is what I've discovered. And I'm telling you this story. It's a true story. It's about one of the reporters who used to be on ESPN Sports. And he said the police were knocking on his door and he was a drug user. And he said he prayed hard. If you'll just let me be negative, I promise I'll never use again. Sometimes people will sit in this court and you know what they're doing? They're praying to their higher power, just saying, hey, if you'll let me be negative, I promise I'll never use again. Now, sometimes your higher power, you know what they will say? No, if you use, you're gonna be positive. Sometimes the answer may be yes, but usually the answer is no.
Yes, ma'am.
So if you're intending to try to wait us out, guess what? You
No,
can't
I'm not-
wait me out, all right?
I'm not trying to do that.
All right, have a seat. We'll stay here until you give me the UA. There you go. Thank you. Everyone, a jury is coming up here at 11:30, so move with the purpose.
Ready? We're ready on 3 weeks.
So the cases remaining, Jessica Desamito with Roger Perez, Abby Marino with Andrew Hicks, Jose Lozano with Raymond Martinez, Alexander Castro with Jason Goss, Guion with Brian Kimro, Wilson with Melina, Antonio Rios, Joe Blakely with Brian Kimbrough. And Mr. Charis is here with Rosales. Gus Gallegos with Robert Guyano. I think I saw Karen Corby. She's with Gonzalez. J. Angel Juarez. You were late. And he's with Carl Basil. Barrera is here on Cantu. Cesar Gutierrez. Victor Garcia. You're Victor Garcia? All right, have a seat. And Ms. Thorne is here. Okay. All right, and as soon as the interpreter's here, we'll take up Jose Amascus. Yes. Oh, no, this is your client, right?
Excuse me?
Is Amascus your client?
No, Brian Maldonado, but we
Okay.
also need an interpreter.
He already has an immigration attorney. It's Eric Bernal. Not today. I haven't asked for Mac today. They say that the immigration attorney is Eric Bernal.
Move to the end so I can talk to them.
So,
That's fine.
all right, he needs an interpreter. He needs an interpreter and he has a detainer. Norma. Norma. Just have him come down. All right, are you all ready on Ruiz?
Yes, Your Honor.
It is very chaotic today. Court is calling 2022 CR 4248A, State of Texas versus Jose Angel Ruiz. Could I have parties announced for the record for the state?
Lorraine Efron for Mr. Ruiz, Teresa Conley. Oh, I'm sorry. Go ahead.
And Ally Jackson, Your Honor, I'm sorry.
Sorry.
That's okay.
Lorraine Efron for Mr. Ruiz, Teresa Conley's not here. I've spoken to my client about his consent yesterday to proceed. Without her, he continues in that consent for this hearing this morning.
And also Renee Munoz as well as counsel judge.
All right, please have a seat. So you all were here for a motion to suppress, and I gave both parties a chance to contact their appellate staff. And I know defense, you needed some time. So the court will hear argument. Defense, it's your motion.
Okay.
And for the record, this is the motion to suppress the cell phone and its contents, correct?
Yes.
All right. All right, I'll hear argument.
Okay.
Briefly, Your Honor, if we could, as part of the issue yesterday, we could just reopen to, inform the court that we filed an affidavit from Judge Delgado with the court this morning.
All right, I don't have a copy of the affidavit.
I can give you a copy of it.
Defense, have you seen the affidavit?
I have.
All right, do you have any objections?
Oh, I do.
All right, thank you. All right, so state you're asking to submit into evidence.
I'll label it State Exhibit C, Your Honor.
All right,
And this is the affidavit from the Honorable Christine Del Prado of the 227th District Court as to the facts surrounding her signing of the certificate.
all right, any objections?
Oh, yes, Your Honor. Number one, it's entirely irrelevant and outside the four corners of the document. It's improper bolstering. I would even submit bolstering in bad faith. I think it's a result of ex parte communications with the district court judge. I have never seen anything like this in 35 years of practice where another district court judge attempts to interject herself in your proceedings to throw her weight around and influence your decision here. It is absolutely wholly inadmissible on constitutional and statutory grounds, and I object again on many things, including irrelevancy, bolstering, and the results of ex parte communications.
All right, so with regards to State's Exhibit number C, of course, the court has to review the document in order to make a decision on whether C will be admitted or not. What I can tell both parties, the fact that Judge Del Prado has placed in the affidavit that she found probable cause to issue the cell phone search warrant, the court is completely disregarding that because it is up to me to decide whether or not within the four corners of the document that the search warrant is sufficient. So I'm not going to consider or let Judge Del Prado's opinion as to the fact that she found probable cause to sway this court and what I will do in regards to your motion to suppress. However, I also see in the document that she is stating there was a clerical error with regards to the date. Does anybody wish to speak to that portion of her affidavit?
She's made herself a witness in this case, Your Honor, and it is wholly inadmissible and wholly irrelevant. And you can, I believe that this affidavit and the return can stand on the four corners or fail, which I believe it will, on the four corners of the document. I believe this is wholly inadmissible.
All right.
Your Honor, it's simply an affidavit clarifying due clerical
It is not simply an affidavit.
All right, so everyone. See, this is one of the reasons why I require everyone to sit. All right, so if everyone will please be seated. And I will hear both parties' argument. And if both parties, if you want the court reporter to be able to get your record for purposes of appeal, then it needs to be one at a time. Defense, I am going to give you the last argument because it is your motion. State, you may proceed with your argument.
Are we arguing as to the admissibility of State's Exhibit C?
Yes.
Okay. So, Your Honor, yesterday we had talked about all of these concepts, the four corners of the document, the full evidence rule. I did review it, and the parole evidence rule says only if it's unambiguous. If there isn't something ambiguous, you can look to extrinsic evidence. And
that's loud. Go ahead.
And we looked at a number of cases, Your Honor. As far as something similar, there was a Green v. State, which is an older case, 799 SWTB 756. This was one actually that involved the Honorable Susan D. Reed when she was in the 144th. There was a clerical error as to the date on a warrant, and it was, I believe, the warrant said that it was 5 days different than the date it was actually signed. And Judge Reed had denied the motion to suppress without requiring any kind of extrinsic evidence to clarify it. And the court actually found that that was reversible because they should have gotten evidence to clarify it. And that's one reason that I'm bringing to you this affidavit that clearly clarifies the clerical error. Additionally, Your Honor, we would rely also on the good faith exception. Clearly, Detective Size, who was the affiant in this case, went to Judge Del Prado and had the warrant signed in front of him as the affiant. And if you look at it, the affidavit is signed by Judge Del Prado, clearly dated with a timestamp. There is the next page, which is the order, which is stamped 1 minute later by Judge Del Prado. And then you have the actual file stamp on the document, which shows that it was filed at 4:45 p.m. on November 27th, 2020. Given all of those factors and given the affidavit, which I do think is important to clarify for the record, we think that, well, it's sufficient on that grounds, but also that it should be admitted and to provide some kind of evidence for the record.
All right, in the affidavit by Judge Del Prado, it state there that there was a clerical error. Are both parties agreeing there was a clerical error or no? Defense, you're not agreeing to that?
I am not.
Okay. All right. Have you completed your argument, State?
As to the admissibility of the affidavit, yes.
All right, defense.
Your Honor, the good faith exception does not go to the issue of the admissibility of this document. That's being confused here with the admissibility of evidence obtained in as a result of the warrant. So I don't think good faith applies here. I don't think, parole evidence is a longstanding rule that applies also in civil cases, and it's sort of, it does not override the constitutional concerns that are at play here under the United States Constitution and the Constitution of the great state of Texas with regard to the Fourth Amendment, Article 1, Section 9, protecting individuals from the entrance of government into their lives. So no, I don't think the parole evidence is enough to support the admissibility of this document. I also think that it is not necessary. The state has within their ability to possibly argue some reasonable inference can be made within the four corners of the document. Whether the court chooses to make that inference or not is up to this court. But I don't even think this affidavit is necessary for that. Basically, they're saying you can make a reasonable inference if you just read this affidavit, this nice affidavit we walked down the hall and got from Judge Del Prado. So I would say it's wholly inadmissible on constitutional and statutory grounds, and it's irrelevant, and I object.
All right. All right. Is there anything else from the defense of the state?
Well, I don't use the word bad faith loose lightly, and I'm not really trying to throw that around so much, but I have never been so offended as I was when I read this to think that the state went and approached the district court judge ex parte on this matter. I will say that I think that is offensive to me as a member of the board, and it's offensive to the constitutions of our great state and country.
All right. So with regards to the affidavit, this is what the court will say. Number one, I understand the defense's concerns. However, Judge Del Prado, the state is making Judge Del Prado a witness, right? So people are allowed to talk to witnesses, whatever witness they want to talk to. It doesn't matter if it's a judge or not. And people are allowed to get affidavits from witnesses if witnesses choose to give them an affidavit. I've read the affidavit because you all are coming to me to decide this. Therefore, I need to read it to decide whether or not it is admissible or not. What I can tell you is from reading the affidavit, and I want this to be clear on the record, and I want both parties to be clear, and I want Mr. Ruiz to be clear. The fact that Judge Del Prado has placed in the affidavit that she found sufficient probable cause to issue the cell phone search warrant has no weight with this court, because I am the person who's to determine whether or not this search warrant is sufficient or not. So the fact that someone else signed it, that has no weight with this court. The court is not even considering that part of the affidavit.
Are you granting my objection with regard to that portion of the affidavit, Your Honor?
Yes. So that is completely disregarded by the court. That is going to not even be considered by the court. Now, the next issue is whether or not, I believe it's defense's, was defense B the search warrant?
Yes,
That you're,
the November 27th, 2023 search warrant, yes.
all right. So with regards to defenses B,
And I haven't argued that warrant yet, we're just on the.
yes, we're on this. So with regards to the defenses B, in the affidavit that was submitted by the state, it's mentioning that Judge Del Prado is saying there was a clerical error. And so I'm trying to clarify from both parties whether or not you all are deeming that in the search, not the affidavit has the judge's signature, which we now know is Judge Del Prado. It has the date, it has the year, it has the time. The actual search that was signed by Judge Del Prado has the judge's name, has the date, has the year, but it has no month. So the question is, are both parties saying that was a clerical error, or are you saying something else?
I'm not conceding it's a clerical error.
All right, state, what are you saying with regards to that?
The state's position is definitely that this was a error.
All right, so with regards to state's exhibit, your affidavit, counsel, there are rules, exceptions to the 4 rules. And one of the exceptions is if there is a clerical error, then according to the law, that's allowed to be corrected extrinsically. And in the affidavit that's been submitted by the state, and what is your affidavit?
It states Exhibit C, Your Honor.
States Exhibit C. What it states is that in signing the warrant, I made a clerical error and did not include the month of November. Both the affidavit and the warrant were signed by me on November 27, 2023. The warrant was then file stamped on November 27, 2023 at 4:45 p.m. Could I please see a copy of Defense Exhibit B, please? Dinah, do you have the exhibit?
I do.
That's okay. They have a copy.
Your Honor, would you like to trade with the mark?
This has a.
Yes.
No, I'm talking on a reference. Separate.
Yes, if I could see that. And then Defense, you have a copy of your B?
Yes.
Thank you so much. So in regards to State's Exhibit C, there's an issue. And I don't want it to appear that the court considered whatsoever the fact that a previous judge found probable cause. That's for me to decide in this case whether or not this search warrant is appropriate. So the court is completely disregarding that. Now, with regards to Defense Exhibit B. Oh, I'm sorry, counsel, you have B off the record. You have B and your B has a February date. This is not the.
Oh, you know what? That's from the prior motion. I'm sorry.
Just one second. Dinah is going to go get the exhibits that were admitted.
Okay, I'm sorry.
That's okay. Norma, can you pass that to her? Correct. Yes, thank you. And my email is working slow, so I haven't received it yet. And we're off the record. And counsel, if you all want to review Somoza v. State, it's 481 Southwest 3rd 693. And then if you want to also review Green v. State, 799 Southwest 2nd 756 and 759. I'll repeat it. Green v. State, 799 Southwest 2nd 756 759. And Somoza v. State, 481 Southwest 3rd 693 700. Yes. No, we can do that. Well, do y'all want to review that law? Do y'all want to review that?
You're talking about case law having to do with the admissibility of extrinsic evidence?
Yes.
I'm ready to go. I
Okay.
do have another response I want to urge the court.
All right, just one second. Yes, if you'll have her come back.
Well, okay.
All right, we're back on the record. And so the court is reviewing Defense Exhibit number B, and that's the November date. So on page 3, we have a signature by Christine Del Prado. And the court is able to tell it's Christine Del Prado because the name is printed as Christine Del Prado. I don't think either party is stating that she is not the person who signed the affidavit. And it's dated November 27, 2023 at 4:33 p.m. That's as it relates to the affidavit. Then the actual search warrant is again by Christine Del Prado. And it says issued the 27th day of 2023, 4:34 p.m. That's what the court has. So, defense, you want to make your final arguments with regards to the affidavit?
I do, Your Honor, because I think that there's some implicit unreliability to this affidavit. And I want to re-urge my concerns regarding the ex parte nature of the communication in approaching this judge seeking this affidavit. Now, look, it is very, you can infer from this affidavit that the conversation went something like this. Hey, we got a problem on this probable cause on this warrant, judge, and we need an affidavit here. And by the way, we also have this issue with the date, missing month on the thing. So maybe if they had just submitted an affidavit that had said, I accidentally inadvertently omitted the month from the return, that would be one thing. But she goes much further to be so bold as to state her opinion about the probable sufficiency of the probable cause. And so I think that it at least raises an eyebrow as to what the nature of those conversations were and how far they went to ex parte the judge on this. And I'm very concerned about that. And I believe on that grounds, it should be wholly rejected. And I believe my objection should be sustained. The ex parte part of this and the fact that those opinions were stated within this affidavit, again, is so offensive to these proceedings. Like, I just cannot understate how strongly I urge the offense to the rights of my client, to the Constitution of the United States, to the state of Texas, to this honorable court. And I think that it should be wholly disregarded and wholly rejected.
All right, why do you keep referring to this as ex parte? It's a witness.
She wasn't a witness when they approached her. She signed it as a district court judge.
No, I understand that, but I don't think the proper term is they ex parte a witness. They're making her a witness. So I don't see that as ex parte necessarily.
Well, if it was only to an extrinsic clerical matter, maybe I could understand that. But the fact that it went so far afield of that in actually stating her opinion about the sufficiency of the probable cause within this affidavit really concerns me. I don't know if what was said about their concerns about the warrant influenced what she said about the clerical error that was made.
All right. All right. So I don't need to hear anymore. All right. With regards to State's Exhibit C, the court is going to sustain the defense's objection, with regards to the second motion to suppress the cell phone. The court has reviewed everything. If you all wish to make brief argument, the court will hear brief argument. Otherwise, I reviewed the defendant's Exhibit B. And the decision I make is going to be made within the four corners of Defense Exhibit B. So is there any other argument that I need to hear?
Judge, just to clarify, you're excluding the entire State's Exhibit C or only
Yes.
the portion? Okay.
All right, so the court is going to make its ruling with regards to the second motion to suppress the cell phone. All right, the court has reviewed Defense Exhibit number B. I understand the issues that both parties, that the defense has with Exhibit B as far as page 4 of the document. The court is going to deny the motion to suppress. The state has stated through Affidavit C, which the court excluded, but which the state stated in an argument that it was a clerical error with regards to page 4. The court is reviewing the document and defense, just one second, in Defense Exhibit B. The affidavit is signed on November 27, 2023 at 4:33 p.m. by Christine Del Prado. Then there's a signature on the search warrant of Christine Del Prado, And it says issued 27th day of 2023 at 4:34 PM. And then there's a file stamp and it's filed with the clerk, and that file stamp states November 27, 2023 at 4:45 PM. This is what the court has. The court is following the four corners of the document.
If I may, Your Honor.
Yes.
I understand that you are denying the motion to suppress with regard to that issue on the date. However, I have other grounds with which I intend to argue on the motion to suppress, which I would request a chance to urge.
Yes, I'll give you a chance to do that. So just so both parties are aware, with regards to the date, the court will deny the motion with regards to the date because it's a clerical error. All right, now the court will hear your argument with regards to the affidavit.
So the state's doubled down now on this timeline, which is interesting to me. So you have before it, well, let me start with this, Judge. Of course, we all know the Fourth Amendment of the United States Constitution and Article 1, Section 9 of the Texas Constitution, protecting the people in the privacy of their homes and belongings from unreasonable searches of the government, right? That's where we start. That's our starting point, right? And we then have to remember that there's no search to be had unless there is a clear communication that a criminal act has been communicated, and that searching the device or place to be searched will be likely to produce evidence with regard to that criminal act, right? And then we also have that we have here, which is warrant number 1. Warrant number 1 obtained on or about February 14th of 2022. And then suppressed on November 29th, 2023. That's it, the timeline of the application and the suppression. Now within the and that warrant's been thrown out, but it's reiterated in warrant number 2 that the discussion that gave the detective rise to probable cause occurred on February 7th. We have February 7th, detective has conversation with witness. February 14th, he applies for the warrant. On November 29th, 23, the warrant and all evidence seized under is suppressed. Okay. My motion to file that warrant and search was filed obviously before November 29th. Well, now, before the ruling on warrant number 1, the state, I think in anticipation of seeing that I was right, goes and gets a second warrant. And they get it 2 days before the hearing on the first warrant. So from November 27th, and that warrant, as you've heard, was obtained, signed, returned on November 27th. That is 2 days before the first warrant was found to be invalid. So I'm not exactly sure how this is circumstance. I wasn't having much luck finding case law on, but what happens when you have 2 active warrants that are purporting to request the same search of the same device? Well, it's got to be suspect, right? I mean, the whole notion of the protections under the Fourth Amendment are that the state does not get multiple bites at the apple, right? They cannot just keep going. The whole idea of protecting against subsequent warrants is because state can't keep going back and requesting a new one every time they get it wrong. They just keep coming back until they get it right. And that is fundamentally offensive to constitutional principles, right? So what we have here is a subsequent warrant obtained 2 days prior to the exclusion of the first one. Now, you take the fact that I think that this automatically sets this in a tone of an eyebrow should be raised and it should be immediately suspect and suspicious to the court as to what is going on here. Then you take into account notions pertaining particularly to the protections with regard to his, right? We know from Raleigh v. California and codified in the Texas Code of Criminal Procedure 180125 that
Just one second. If you could slow it down, especially when you're quoting cases, because the court reporter has to put that down. And I can tell you, when people rattle off numbers to me and you're typing it, sometimes it takes a while.
Okay, I apologize to the court reporter, opposing counsel. But I will say, we have overriding concerns here, particular concerns dealing with the protection of cell phone searches, right? So we're not even talking about a search of a place or a vehicle. We're talking about the search of a cell phone. And the Supreme Court of the United States has told us that because of the intimate and volume of information contained within a cell phone, the personal nature of that enormity of contact, that cell phones deserve some special protections. And we know that Texas has codified, in the Texas Code of Criminal Procedure 180125, there are very particular requirements pertaining to the issuance of a cell phone search. I will tell you, it is my opinion that under 18, and I hope I'm quoting that correctly. 180, I just had it in front of me. Okay. That this warrant fails under 18.0215. This warrant fails because under 18.0215, it is very specific, which is necessary to be contained within that warrant to be a valid warrant of cell phone. If I may put that to a side for just a moment.
Yes.
I want to go back to the contents of the affidavit on warrant number 2, which are, if you compare the two warrants, a lot of the information from warrant 1, from affidavit 1 and affidavit 2 are basically cut and paste. In cut, copy, and paste, right? So I think we can all agree, I hope we can all agree, that everything that is identical in affidavit 2 to affidavit 1, all of the identical information should be out, right? It's already been ruled on and it's out. So if we extract all of the inadmissible and offensive language that comes from warrant 1, and we remove all of that, and we're left to what's left in warrant 1. I mean, wait, if we take out what was in warrant 1.
Which is Defense Exhibit A.
Yes, Your Honor.
All right, so you're asking that be removed.
Well, I'm asking, I can read into the record the portions that are identical.
No, I'll let you do your argument.
Okay. There are some portions in warrant 2 that are newly added.
So warrant 2 is Defense Exhibit B. I'm trying to make sure that the record is reflected correctly.
That is correct.
All right.
That is,
So warrant 1 is Defense Exhibit A. Warrant 2 is Defense Exhibit B. Is that correct?
yes.
All right.
I'm sorry, Judge.
No problem. I just want the record to be clear.
And I might be getting it a little confused myself, and I don't mean to, and I apologize. So what I'm talking about now is the warrant from November 27th, 2023.
All right.
May I sit down, Judge?
Yes, I keep telling everyone to do that.
Okay. So the parts of the November 27th to 2023 warrant that I have identified as being newly added are included in the 3rd paragraph of the probable cause facts.
Which page?
That's page 1.
Okay,
It's the third paragraph from the bottom. The number 1 was added after witness.
all right, so you're saying what is new is from page 1,
Yes,
the third paragraph.
sorry, the number 1 after witness, that number 1 is new. And then the second line, beginning with witness 1, also described receiving video footage on his cell phone from the defendant's cell phone, showing him disciplining the victim. Witness 1 said, while watching video footage, she could see the victim holding up something in her hand with her hands while crying and saying that it was too heavy. Witness 1 could also hear the defendant saying it was the victim's punishment and she needed to keep the item lifted. That's the newly added information in that paragraph. It's not a crime. That doesn't describe a crime. Okay. The other newly added part is the following paragraph, the second from the bottom, which states the victim's then 6-year-old sister, hereinafter referred to as witness 2, later made an outcry that the defendant would make her and the victim take off their clothing while in the shower and would take photographs of her and the victim. Those are the newly added parts of information in this November 27th, 2023 warrant. I would submit to the court several things. One being, none of that describes crimes. It is not a crime to discipline a child. It is not a crime to make a child hold something up. It is not a crime to make a child take off their clothes to take a shower. None of those are crimes. None of this describes illegal activity. None of this provides any information which supports that. Okay, there's no crime described here. If you think there might be a crime described here, there's no information contained within this affidavit which suggests that there is likely to be found evidence on the cell phone. In other words, they say, the witness describes receiving footage on her cell phone from the defendant's cell phone, showing him disciplining the child. Then it goes on to say that the defendant would make her and the victim take off their clothing while in the shower and would take photographs. There's no information that links those activities to this cell phone. In particular, the alleged photographs in the shower. We don't know if they were taken, those photographs were taken by a cell phone, camera, or some other recording device. We don't know who took those pictures. We also have within that paragraph some information that witness 2, who's not identified, later made an outcry to some unknown person who's not identified, that there would be these non-legal pictures taken. I mean, we can't infer they were illegal. It's not describing an illegal activity. So I would say that if you might be able to say, and I anticipate the state will say, that with regard to that paragraph with taking photographs in the showers, that was later acquired information from an independent source.
Right. So here's my question. So are you saying that before there was a ruling on Defense Exhibit A, which is the first warrant, the state obtained Defense Exhibit B, which is the second warrant?
Yes.
Okay.
Yes. And I think that alone would support the suppression of this warrant. But I would also say that to the extent I anticipate the state will say, look, this second warrant can stand on later acquired information from an.
Oh, and counsel, I'll give you final argument because it's your motion. So you don't have to anticipate what they're going to say. We're going to hear what they're going to say, and then I'll give you final argument.
Okay, I'll pass it this time, Judge.
State.
Okay, Your Honor, first off, I respectfully disagree with defense counsel. I think the, having them take off their clothes and get in the shower and take photos of them is definitely describing, indecency with child by exposure. It could be child pornography. It could be a number of offenses that justify this on itself. Secondly, there was a lot of talk about the first warrant, and as you recall, Judge, I was concerned about an argument being it's the same grounds. And I heard defense counsel say that a little bit. In essence, she said, well, you have to disregard everything that was said in the first warrant that's also in the second warrant. Well, that's not what it suppressed. It suppressed the search. It said there weren't enough facts in the first one. It doesn't mean you can't talk about anything from the first warrant, and the facts are the facts. Detective Size interviewed the mother of Mercedes, the deceased child in this case, and through that interview, he found that Jose Ruiz had at least one occasion filmed Mercedes holding an object that she was too young to carry and forced to continue holding that object. When you look in conjunction with the first paragraph, when it talks about how this 5-year-old was deceased and that she had multiple injuries covering her body. If you have that information, and then you have information that he was filming the child in an act that some would argue borders on excessive punishment. Excessive punishment also includes injuries. It also includes abuse. It was an abusive act that he saw. Now, as to the probable cause, Your Honor, I will just point the court towards Werenberg, Wehenrenberg v. State, that's 416 Southwest 3rd, 458. This was the Court of Criminal Appeals. It was their pivotal case on what's called the independent source doctrine that specifically deals with subsequent warrants, subsequent search warrants. And following that case, out of Bexar County, very recently, we had a case, Anton Harris v. State, where there had been a DNA warrant that was done. The state, on its own, without that warrant being suppressed, went and got a new warrant. And on appeal, they basically argued that you can't do that because the first warrant was not valid. And the Court of Appeals at the Fourth Circuit clearly said, well, yes, you can, because there was an independent basis. And defense counsel said it herself. There's new information in this new warrant that was not in the first warrant. That new information within the four corners, I would argue the first warrant is irrelevant, really. Within the four corners of what we have, it stands on its own.
Okay.
There was also mention of having two warrants acted at the same time. As the court knows, there is a statutory period where a warrant can be executed. So I don't believe that's accurate. And I also don't think it changes the facts of this case. That this is a independent, valid search warrant. There was probable cause. You had a dead child with injuries. You had a video of a child being abused, and you had another child who was there saying that he would take naked pictures of them with his phone, which, as you know, inside the affidavit is an iPhone 13 Pro Max, which is definitely capable of taking these photos.
All right. Defense, your final argument.
Yes, Your Honor. So I would submit, I'm not acknowledging that it's new information. I acknowledge it's newly added information.
Okay.
Okay. And the first warrant from February 22 was thrown out based on the insufficiency of the affidavit. They can't resurrect what was already insufficient to bolster this one. It has to stand on what was newly added and is purported to be independent source of later acquired information. And I would submit to the court that in the paragraph, the third paragraph, where witness one says, she also described receiving footage. She said while watching the footage, she could see all of that was clearly information the detective had on February 7th, 2022.
Okay.
There's no way that that can be read to be anything that is close to later acquired independent source information. It was information known to the detective when he got the first warrant and didn't put it in. Even if he had put it in, I think it's still insufficient. It's a full probable cause. I think number 3 goes out. I think he could have added a lot of detail that would have made this a valid warrant, but he didn't. And then the second from the bottom paragraph, where he says later made an outcry. Wait, later made an outcry has no particularized facts or detail as to when later was. If it was February 7th, February 8th, February 9th of 2022, or some other time after the first warrant was, we don't know when that later, what that later meant. And so there's no way to determine if it's later acquired or even independent source.
Okay.
We don't know who the outcry was. The detail is wholly lacking here to support any sufficiency to support the warrant and the search. We ask the court to grant our motion to suppress.
All right, thank you. We're off the record. Could I see defense exhibit number A, please? And then I'll review that. And if you all will step back and I will give you my ruling shortly. Could I see Mr. Edwin Rosario Montez?
Yes, sir.
All right, so what are you positive for?
I came out positive for cocaine, which I don't know why, but the marijuana, I didn't think it would be in my system.
All right, so here's my question for you.
Yes,
Why are you being dishonest with the court? You're on deferred adjudication for a case that could land you in prison for life.
Yes, ma'am, I understand that.
So you're not supposed to be using, there are other things that are going on in your life. I don't know what, but
If I asked you, you could refer me to a counselor maybe? I'm
no,
not gonna lie, I've been,
no. Now you're trying to backtrack with me and I don't appreciate that because I asked you if you were going to be positive. I remember we had this whole conversation about people's higher power and you still sat there drinking water and I'm sure you were praying that you would be negative.
no,
And the answer was you're positive and you're positive for marijuana and you're positive for cocaine. All right, so this is what's going to end up happening. You're going to take a seat in the box and you're going into treatment today.
the treatment,
Mhm.
what is that?
All right, just have a seat in the box. Trayvon Stevenson. All right, what is this concerning?
We're just gonna address the court. We're gonna just talk about, he was back in November. He was granted probation. Asked to be assessed for drug court. And the alternative looked in SATF, but we are 4 months later, he's still in the jail. So I've been talking to probation. He was assessed for drug court back in December,
Mhm.
denied drug court.
And why was he denied drug court? Probation, this is Trayvon Stevenson. Do you know the reason he was denied drug court?
Yes, but
The judge said it was because of.
You probably want them to answer.
It says ADH due to violent history and supposed drug dealing.
All right, so that's why you're not in felony drug court. So you need to go into somebody's inpatient treatment. So that's where we are. I understand there's been some wait time. Where is he on the list?
Judge, as I told counsel, there was some mix up with his cases, the 3 cases, and which ones he was actually mandated that if not accepted into felony drug court. Currently, he is due for medical tomorrow. And then 1 to 2 weeks after the medical clearance.
All right, and so that would put us at so then he should be transferred by the end of March.
Yes, Judge.
All right, so what we're gonna do a phantom date, Ms. Ferguson, on this case, March 25th, put it as a phantom date. So he should be transferred by March 25th.
Yes, Judge.
All right, so if he's not transferred by March 25th, the court would do something else.
All right, thank you, Judge.
Thank you. All right, thank you. And Ms. Ferguson, make sure that doesn't show up as a date in the system. And that's Trayvon Stevenson.
Thank you, Judge.
You're welcome. Thank you.
Yeah, Coach.
Yes.
I stepped out to the bathroom 1 second.
Oh, no, he's just sitting over there waiting so we can discuss in more detail the marijuana and cocaine. Diego Mascara. Yes, come down, Mr. Mascara.
It's Spanish.
He's
Oh, in Spanish?
And that's fine.
Just have a seat, Mr. Mascara.
She's asking for another attorney to be appointed because she doesn't speak Spanish.
Okay, all right, just have a seat. Who's the attorney here who speaks Spanish?
Okay, okay.
All right, Mr. Charis. Oh. Let me go with him because there's probably going to be an immigration issue. All right, if you'll come forward, sir. Normally, there we are.
And Judge, the jurors are you.
Okay.
May I be excused or you need to?
Yes, you can be excused.
Thank you, Judge.
Thank you.
Are you on the appointment wheel?
I am not gone.
All right, sorry.
Okay.
We need someone who's on the appointment wheel. Mr. Charis.
Yes, Your Honor.
All right, if you could represent Diego Mascara, and the state will give you information.
Okay.
All right, thank you, and he's a Spanish speaker.
Okay.
Thank you. All right, everyone else, you need to move with the purpose and with the plan because we are recessing at 12. And Jose Lozano,
Yes, Your Honor.
yes, you're all ready for jury trial?
I would like to get ready here. I will find him. Give me 5 minutes, Your Honor.
All
I
right.
think there was some late exchanges.
All right. And who is with 401? In the prosecutor's office, who's? Oh, okay. Yes. Yes. Sure. Okay. Cesar Gutierrez, who is that?
Christian, Mr. Gutierrez apparently is not present this morning.
All right, just give us a moment. The court reporter took a 5-minute break
Okay.
and we'll put it on the record.
That would be great.
Thank you. Yes.
Say, I'm in school.
Yes. Okay. Is he here today? Mr. MSQs? Okay, just give me a moment on that. Hello. Yes, on your case?
Yes, sir.
Yes. You all ready for trial?
Judge, we got some new discovery last night. We've been going over it. We think it's lacking in specificity that we need for trial.
What new discovery?
Some insurance claim reports. We've been asking in discovery motions and in prior settings for a long time for confirmation from the insurance company. What did they pay on these items? There's a dispute over the value, right? So that would give us some insight as to the value based on what the insurance company paid for it. We got that last night.
All right, so either it's coming into trial or not. This is 22 settings.
I understand.
Yeah, we're going to trial. Okay. All right, is there anything else?
I think we've already made it clear that was not submitted in the discovery acknowledgement.
All right, then
Yeah.
people need to file motions of what they don't perhaps want excluded.
I understand, Judge, but we just saw it, so I'm not involved in doing motions because I just was here.
All right, I'm sure the state is not going to object to you doing an oral motion, but I will give you all a chance to go to your office and come back and file whatever motion you wish to file.
When would we be, is that our jury outside?
Jury's outside. I'll have them come back in the afternoon.
Okay, well, whatever we need to file, we'll do it between now and then.
All right, so if you all to go, whatever motion you want to file, and maybe talk to the state, maybe they want to object to an oral motion.
So we're starting it with them.
Well, y'all want to discuss that and
We
then
will
that will,
discuss it, actually.
well, that will make a determination of when we start after y'all discuss
Okay.
that and give me some more information.
I just ran a fresh inquiry and there was like 5 pages of journals.
Everyone, we are recessing at 12. Do not rush the court at 11:45. Miss Christian, I have yours, so that will be taken care of. But everybody else, do not rush the court at 11:45 because we're going to break at 12.
Judge, to clarify, jury trial list, that means everyone comes back.
Yes. So the people who are coming back. And I'll have y'all come back at 1:30. Everyone, I'm sorry, not 1:30, 1:20. Everyone listen up. Jose Lozano, 1:20. Alexandra Castro, 1:20. And where is Brian Kimbrough?
Choose plenty.
Yeah, I'll do that. Deputy Mejia. From page 1, we need Abby Marino.
She's in the.
Oh, you're ready? Okay. Jessica Desmito.
Just walked out with her attorney.
Okay. We need Luis Guillon, 120. Sarah Wilson, 120. Antonio Rios. Could you pull the file for Antonio Rios, please? George Santabanez. You need to be back here at 120. John Lyles, that's going to be 120. Roberto Rosales. All right. Gus Gallegos, 120. Jose Gonzalez. All right, you're going to have to come back at 120. Jay Juarez. Where's Carl Basil?
You stepped out to the 379.
Yeah, that's 120. Renee Cantu.
Yes, Your Honor.
All right, 120. Victor Garcia. 120. Roberto Rosales. I see you're all in the box. Robert Solis. 120. Jordan Estrada. 120. Albert Bishop. 120. Darian De La Rosa, 120. Christopher Gonzalez, 120. Sierra Brandon, 120. Dylan Parker. All right, we'll take that up. All right, could I see the files on Antonio Rios, please? All right, and I need Dylan Parker.
Dylan Parker, Judge, is gonna come back another day. They didn't give me notification on it. Sean had asked me to get on for today.
Who didn't give who notification? It's set on the docket for a plea.
That's what I was told by Rashawn.
We tried to bring him in today so that he could plead out before Veteran Treatment Court accepts him on Thursday.
Okay.
He said he wasn't given notification to be here today. So,
All right, so let me see the file on Dylan Parker.
so Judge, we can have him here at 9 o'clock in the morning so that the plea can be done. If it doesn't get done before Thursday, Veteran Treatment Court is gonna push it out.
All right. All right, and then I need the file on Jordan Estrada and Robert Solis. All right, and Melissa Christian, who's your client?
Cesar Gutierrez.
Court is calling 2024 CR 1109, State of Texas versus Cesar Gutierrez. Could I have parties announced for the record for the state?
Jason Garahan.
Defense?
Melissa Christian for the defendant.
All right, this hearing was scheduled at 9 a.m. It is now 11:39 a.m. Defense, your client has not appeared.
I have not heard from him, Judge.
All right. And Deputy Laura is making an announcement. All right, Deputy Laura, did you make an announcement for Cesar Gutierrez?
Yes, Your Honor, there's no answer to that name.
All right, State.
State's requesting a bond forfeiture, Your Honor.
All right, that will be granted and he'll be remanded without bond. If he makes an appearance, the court will reconsider.
Thank you, Judge.
All right, thank you.
May I be excused?
Yes, you may.
Your Honor, I did not hear you call my client.
Brian Maldonado.
Oh, just one second. You say, what's his name?
Brian Maldonado.
Let me see what page he's on. Ah, yes, he's supposed to be, have him back at 1:20.
Okay.
All right, thank you. All right, Dylan Parker. Yes.
Real quickly, Judge, also my client, Marcelino Tovar Padilla, he's in custody. I didn't hear you calling for.
Oh, he'll be back at 1:20.
Okay, perfect. We're both dressed for trial.
All right, thank you. Antonio Rios.
Judge, while you're
All
waiting,
right.
I'm ready to do the oral motion on limiting whenever the.
Just one moment. All right, could I have a prosecutor?
Yes, sir.
Court is calling 2023 CR 11520, State of Texas versus Antonio Rios. Could I have the state announcer?
Jason Garahan for the state, Your Honor.
All right, this hearing was scheduled at 9 a.m. It is now 11:41 a.m. and the defendant has not appeared. All right, Deputy Laura, did you make an announcement for Antonio Rios?
Yes, sir, visual answer.
State?
Judge, the state is requesting a bond forfeiture.
All right, that will be granted. He will be remanded without bond. If he makes an appearance, the court will reconsider. And Deputy Laura, would you let the jurors know that we're going to have them back up here at 1:30?
Yes, sir.
All right, thank you. And then Vashawn, when did you want to bring Dylan Parker back? All right, so we'll do a recall on him for tomorrow. State, Dylan Parker is going to come back tomorrow at 9 a.m. He's on the recall docket and it's for a plea. Yes.
Solis never appeared. He was notified to be here. It was supposed to be a compliance hearing.
All right. On that, then file a motion to revoke.
Judge, may we approach?
Just one moment. Can I see the file on Robert Solis, please? All right, that's done. All right, Alexander Castro.
Morning, Judge.
Good morning.
Mr. Castro is present.
Hi.
Look,
Yes.
Judge, we just wanted to touch base with you. The state gave us a phone download about a week ago, I guess.
No, it would have been about 2 months ago.
2 months ago. We have been trying every way possible to get it open. We can't get it open. we're trying to deal with them. I understand there's also a statement from USAA and some records that are now available from last week. That being said, we'd like to make a oral motion for continuance.
No, I'm not considering an oral motion for continuance. This is 9 settings. So if you all want to file a motion, you can. I'll make a ruling on that. Otherwise, she needs to be back here at 1:20 because this is scheduled for jury trial today.
Okay.
All right, thank you. Anyone ready?
I'm ready on Mr. Rosales, but also on Diego Mascoro.
Yes.
It turns out he's not even here. I talked to this gentleman. It's a completely different person.
Oh, why does he keep saying his name is Diego Mascaro?
Oh, he's on the docket today, but he's not Diego Mascoro.
No, Judge, what happened was that with Mr. Mascoro, he is not stable and he is not very compliant, refusing to come. They've been trying to bring him since early this morning and they still have not been able to convince him to come.
All right, and is he a Spanish speaker?
I'm not sure.
All right.
I don't know, Your Honor, and so just to be honest, I don't know, you know. I
He's
don't wanna
considered
label
mental
him,
judge.
but
All right.
he's- I'm probably still stuck on it now.
So this is what we need to do then. Counsel, I'm going to need you to make sure that you visit him, which I know you will. And we're going to recall this.
Well, we can try to get him over, who knows?
Well, we're going to recall it for March 19th. Ms. Ferguson, put this on the docket for March 19th.
Did you want to go ahead and take off Mr.
Yes.
Albert Driver's off?
Yes.
Reappoint him?
Yes. All right, so we'll put it on March 19th. If you discover that he is a Spanish speaker, let us know. Mr. Charis, if it turns out he's a Spanish speaker, then we'll still put you on it.
Yes.
And then counsel, if you discover he has mental health issues and it would not be conducive to bring him, just let us know before March 19th.
And that was gonna be what I was gonna talk about anyway, prior to mine. Speaking to this poor gentleman, who I thought he told me
Okay.
his name was Diego Mascoro, but
All right,
sorry about that, Judge.
no problem.
Okay. Okay.
I need your bar number.
Yes, yes, I'm sorry.
It's okay.
Jay Juarez, Mr. Juarez. All right, what is happening with this case?
Your Honor, I've conferred with the state today. The state has made an offer. My client would like to talk to his mother. He's 18 years old and wants to run it past her, and I can set up a conference with them. We're talking about trying to bring it back on Thursday. So,
All right, is Thursday enough time for you?
Yes, ma'am.
All right, so we'll recall this for March 7th.
thanks, Chairman.
All right, Ms. Ferguson, if you give them a reset on Juarez for March 7th.
Thank you, ma'am.
You're welcome. Thank you for dressing appropriately for court. All right, this is the last case before break. After this case, we'll come back at 1:20. So this is it. Roberto Rosales. Court is calling 2024 CR 2752, State of Texas versus Roberto Rosales. Thank you. You know how it is.
Sorry.
Can I have parties announced for the record for the state?
Support for the state of Texas.
Defense?
Albert Chidas for Mr. Rosales.
Are you Roberto Rosales?
Yes, ma'am.
All right, off the record, excuse me. Y'all can't talk behind the court reporter. You can ask the deputies. They'll move you down to the other end. We're back on the record. And for the defense?
Albert Chidas for Mr. Rosales.
And are you Mr. Rosales?
Yes, ma'am, I am.
Counsel, have you received all the discovery and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Rosales, I'm showing you what's entitled application for deferred adjudication. Did you review that with your attorney?
Yep.
Did you understand it and did you sign it?
Yes, ma'am, I did.
All right. And did you review what's entitled true bill of indictment with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Oh, we are, Judge.
Mr. Rosales, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand you're charged with the offense of evading arrest, detention vehicle? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison. Thank you. And up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, yes?
I apologize. I thought I was getting charged with the drug and then that one was getting dumped or getting removed.
Sorry, and that.
Just be clear because she has.
I apologize. I thought there was two charges and one of them was being removed, or I don't know if I'm supposed to say that.
No, what we're focusing on now is the fact that do you realize that you're pleading to an evading arrest detention with the vehicle?
Yes.
I mean, you're very slow with your answer on that. So do you know
Um,
what you're here for today?
Yes, ma'am. An invading arrest and there was a drug charge as well.
All right, so I want you to listen to my
Yes,
questions.
ma'am.
All right, do you understand that you're about to enter into a plea on an evading arrest with a
Oh.
detention vehicle?
Yes, ma'am.
All right,
I
so
apologize.
listen, no. Just listen to my questions. All right, by indictment, in this cause number that you're about to enter a plea into, it's an evading arrest detention with a vehicle. Do you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, I do.
Do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am, I do.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am, I do.
Counsel, has your client been able to provide you with any defenses?
He has, sir.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Rosales, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea, there's a $500 fine. State recommends deferred adjudication. The state will take in consideration 2023 CR 9927, and there's $57 restitution to DPS for drug testing. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State.
It is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. State is requesting that your deferred adjudication be for a term of 4 years. There be a TAP evaluation and 120 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am. I do.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No.
State any evidence.
Yes, Your Honor. State exhibit number 1. No objection, Your Honor.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor. Yeah.
All right, anything you wish to say on behalf of your client?
No, Your Honor.
All right, are you employed?
I actually have a job interview right now,
What, doing what?
selling insurance.
Oh. Do you have any children?
I have 3 sons,
What are their ages?
15, 10, and 4 years old.
Do they live with you?
No, man, two of them live in Eagle Pass.
All right. When's the last time you seen them?
It's been a good while, I'd say about 1.5 years.
All right, why are you evading in a vehicle? That's very dangerous.
Yes, ma'am. I understand I have a lot of traffic warrants, and I did know that I had something on me that I shouldn't have. and
Well,
I
here's the thing.
Panicked, and it was a terrible mistake.
You know what ends up happening?
Yes,
Now you have a felony instead of maybe somebody having you to pay traffic tickets.
Right. I understand.
All right, can you tell me what the court cost is on a 3rd-degree felony, please, evading? All right. If you're drug tested today, what are the results going to be?
I will come out with some positive for marijuana.
All right, what else?
That's it, actually.
No, I mean, are you backtracking, trying to
No,
figure out what you've used in the past?
Yeah, I was thinking if I would test 30 for cocaine, but. Okay, I was thinking if I would test 30 for cocaine, but I will not.
When's the last time you
It's
used?
been about 10 days.
All right. How often are you using cocaine?
I'd say maybe 2 times a month. Before it was pretty bad, but I've got it pretty under control now.
All right, and who is Abigail?
That's my daughter that passed away.
Oh, I'm sorry to hear that.
It's okay.
All right, so I'm going to sentence you to 4 years deferred adjudication. There's a $500 fine that will be probated. Taking consideration 2023 CR 9927. There's $57 restitution to DBS for drug testing, 120 hours of community service restitution. I'm going to require parenting classes. Once you complete those classes, once you complete those classes, your community service hours will be deemed to be satisfied.
Okay.
There's going to be regular reporting by Zoom or in person, regular UAs. I'm going to want 90 sober meetings from you in 90 days.
Okay.
Ms. Abrams, do you have any violent history in your past?
No, ma'am, not in my past. I am currently. Oh, yeah, no, I don't.
Right.
Just got 2 cases dismissed. For something that was violent, but it was dismissed. I don't know how else to say it. I don't want to
Okay.
kind of tangle myself over my words. They just got dismissed like 4 days ago.
All right. In another county?
No, ma'am, it was here.
All right. I'm going to do a referral to felony drug court. If not accepted, then make sure we do a TAP and follow TAP recommendations. If they ask for inpatient treatment, we'll start with outpatient treatment. Proof of employment within 30 days. There should be no employment as a home healthcare provider or with minors. Field visits 1 time per month until in treatment. Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
No, ma'am.
All right, the court cost for this case is $395. Will you be able to pay that in installments?
I can't at the moment.
No, I mean, in
Oh, yeah, of
installments. You
course.
won't be expected to
Yes,
pay
ma'am.
it today.
Yes, ma'am.
All right. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am. Okay.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal.
Okay.
Do you understand?
Yes, ma'am, I do.
All right, from here on, we can go off the record from here on out. Everything you do, you need to ask yourself, could this potentially result in me going to prison for up to 10 years? Do you understand?
Yes, ma'am.
All right, thank you. All right, and I'm going to make my ruling on, Mr. Ruiz is already back.
Yes, we took him back on 15 minutes back.
No, everyone, if you'll come back at 1:20, I'll give you my ruling on Mr. Ruiz. All right,
May we be excused, Your Honor?
yes, he just needs to go over things with probation, and everyone, you need to come back at 1:20. We're on lunch break.
Thank you, ma'am.
Thank you. All right,
Back at 1:20.
let me see. Mr. Montez. Ms. Abrams, what would you like to do with Mr. Montez, your recommendation?
At this point, the recommendation would be for him to. I'd like to restart him, do another round of intensive outpatient treatment. IVR hotline. Sober support meetings, 90 and 90. And he needs to provide verifiable proof of employment every 30 days.
All right. So that's what's gonna happen to you. You're restarting everything. Do you understand?
Yes, ma'am.
And you're gonna do 90 sober meetings in 90 days. You're gonna call into the UA hotline. You're gonna provide proof of employment every 30 days. If you fail to do any of these and there's not a good explanation for it, what's gonna end up happening is they're gonna file a motion to revoke. And you know what happens when a motion to revoke is filed? You're arrested wherever you are. Do you understand?
Yes, ma'am.
Is there anything else you need from the court?
No, ma'am, I just want to say thank you.
All right. Good luck to you.
Yes, ma'am.
All right, you can release them. All right, so everyone, your case is, if your case was not taken care of, you're coming back this afternoon at 1:20. Yes.